kept as 31st, 1 day prior to school reopening, all the uniforms
30th,
and other things.
30th May. Full stop. Next point. Since the birthday of the child falls on 17th April, the father shall have the first half till 2 p.m. and the mother shall pick up the child from the residence of the father. You drop the child better.
I will drop the child.
The father shall drop the child to the residence of the mother on 17th at 2 p.m. The child shall spend time with the mother till 7 p.m.
Yes, yes.
And the father shall pick up the child from the residence of the mother at 7 p.m. 1 hour buffer time is granted on both either handing over and taking over the custody of the child. Full stop. It is hoped that the both parties cooperate rather than espousing their ego and anger against each other. Full stop. Parties are at liberty to approach the court in case of any difficulty.
My lord, one more submission, my lord. Now, because there's a long period of stay away from either of the parents, may the other party be granted the weekend.
So the period of her visitation rights gets suspended during April. So
Either
also
ways
you
is
will
fine.
not have during May.
Either ways is okay. My
So
suggestion was the opposite, but if that is also,
that's why I said in case of any difficulty, you can move the vacation court.
Yes, my lord.
Because let both of you have full custody of during this period when the child is pending.
But
Yes, my lord,
however,
because that
if
is
at least daily
just-
one call to the other.
All right,
is,
we'll make the calls available. You can have calls on all days during this period of the summer and
My lord, 1 second, my lord.
winter vacations.
My lord, the call, during the duration of the call, he is actually trained because nothing is being done from our side. He's trained that, you have to speak in a certain way and all of the call recordings are fake.
Give the basic phone. Give basic phone.
Basic phone also, he'll be able to record it and that is.
Doesn't matter, madam, that you can't help it. Record. Either of the parents shall have the liberty to speak their child on every alternate day for a period of 15 minutes between 6 and 7 p.m.
Yes, my lord.
Between 6 and 7 p.m. during the visitation, custody and visitation.
My lord, with
Anything
respect
else?
to the case,
Anything else?
No, my lord, as far as the calls are concerned, I think he's getting confused with the calls because he's very scared that, after he gets back, whether he's, punished for disobeying or something like that. That's the reason
We'll
why he
see.
stopped.
Let us see. Now we have to also see how he is going to behave. How you are going to treat also has to be mattered. All.
my lord, with respect to order dated 23/2026, this is not with respect to the case.
Yes.
But as against the allegation that was made against me and this further affidavit that speaks additional allegations,
Yes.
not just what was told in open court, but additional allegations.
Yes. That is in which case it is.
5229 case is when
The order sheet is maintained in which in both.
in both cases.
Content in the gate as well. So that order is passed in both the case. Where is that order? Date?
20th March
20th.
2020 March 2025.
20. But in view of, despite the petition being disposed of, in view of the order passed by this court on 20th March 2025, this petition is posted after. When do you want this now? This will have to be decided. We can hear this later. There's no great urgency.
No great urgency.
So this matter after the summer vacation to hear on the order passed on 20th March 2025 with regard to certain contemptuous nature of the statement made by the respondent in the open court against the learned counsel for the petitioner. Okay. List this matter on. So with regard to the merits of the matter, it
Sir,
stands disposed only with
yes.
regard to the
With regards to the
contemptuous
contemptuous
nature.
nature of
Yes.
what the statements that she's made in open
yes.
court.
Yes.
My lord,
Yes, Mr. Arun.
Sought for modification of your lordship's order, your lordship.
Lord,
On the last occasion, your lordship had passed an order wherein an affidavit was sought to be filed. The affidavit at a later stage, your lordship had stated in chambers that the affidavit should have specific date that she will be appearing today. Though the affidavit in fact went a step further, stating that all the dates whenever required, she would be present. The other one issue your lordship had raised was that they're stating that that shifted. Your lordship, it is true. All this material, everything has been shifted. On 31st, she was asked to vacate the premises.
What is this you are filing now?
We are sought for modification of the order. Your lordship, this is an arising out of the order of the lower court, wherein the lower court had refused to grant an order to the husband stating that the wife should not leave the family court jurisdiction. That order, your lordship had passed an order leaving liberty for us to seek modification if required. Your lordship, had filed this matter I had moved the matter more than 10 days ago. And after 2:30, the learned counsel for the other side submitted that, yes, we will try to negotiate and see if there's a possibility that both of them would reconcile. That did not happen. They did not even come to the reconciliation. Not one step was taken. They said that first he would want to see the child. None of that happened. After that, thrice I have moved the matter. Thrice the lordship has accepted the memo, and yet the file went missing. And after mentioning that to your lordship, and your lordship said, keep that person present, why the file is missing, then this file suddenly resurfaces after about half an hour itself. Then the matter was taken up. Your lordship had submitted that in fact he is the one who left the premises, and then wrote to the house owner stating that he would not be living in those premises anymore, and that the amount could be refunded. And that is when your lordship, she took a call that she would
pass the order, not restraining the respondent from leaving the jurisdiction of this court, of the family court, Bangalore. Even on the day of the order, 22nd of March, which was a Saturday, I had visitation morning to evening. That evening, the order was communicated to her. And my lord, this is how she writes: visitation will stop, no more visitation. I have not seen my child, I have not spoken to my child. I've been, my lord, pleading with her every single day to allow me to speak to the child. There has been no response. Not with your lordship's kind permission, not copy has been served. After your lordship's order is, kindly see the conduct. A person who comes before the court by not seeking a discretionary order at your lordship's hands. Exercise of writ jurisdiction. Page number 8, my lord.
You've given a copy of this?
Yes,
No,
copy was
I've
served.
received
Copy
this.
was served.
Yes,
Page number 8, my lord.
Yes.
22nd is your lordship's order, my lord. It was passed, the interim order was passed on 22nd of March. On the same day, I communicated, my lord, after receiving the order copy, page number 8, the petitioner writes to the respondent, please find attached the Karnataka High Court order dated 22/3 as received from the council, so and so. Note, at the bottom of the page, she responds, received. Visitation will now be decided by courts. Please not come henceforth meet the child. On that day, from morning to evening, the understanding they have is Saturday morning and Sunday morning. Morning to evening, he picks up the child from the respondent's residence and takes them to his parents' takes the child to his parents' residence. From the date of your lordship's order, my lord, I've not seen now more than 2 weeks. The respondent is present before the court. I have been writing emails every single day, my lord, requesting her to permit me to see the child. So not considered. Therefore, my request is, let me kindly permit me to spend some time with my child, interact with my child, because my parents and I have been deprived of a company for more than 2 weeks. And deliberately only because after the order is filed, very suspicious. After the order is filed, very suspicious. Highly suspicious, from day one. And the submission that I have not been supporting the respondent financially, is incorrect. I have gone on record even before these proceedings commenced, telling her that I cannot pay 70,000 rupees rent just for her and my child to stay in an apartment. I'm willing to pay 50,000 rupees per month. I will take care of all of the child's expenses.
What is it?
No, the issue, yes,
My
now
time?
the family court has passed any order on the visitation
Nothing.
rights?
Nothing.
Neither your lordship nor the
No,
family court has passed
at the
any
time of
order.
At the time of issuing notice, I had sought an ex parte ad interim order of
Order
injunction.
39, rule 1 and 2
Yes,
was
Lord.
not
Yes.
given.
Yes, my lord.
So you come here for that ex parte order
Yes.
was passed by
Yes,
this.
Yes.
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 And might I, this is my
Section-
modification order. If
No,
I might,
I will- I will-
commence, they can conclude after that, your lordship. Your lordship, I have filed an application.
Hmm.
Your lordship, the modification. No, modification. I'll go to you.
That-
One is a modification application, another is a memo, your lordship, with additional documents.
Modification.